Morning, Ms. Morse.
Hi, good morning, Judge. Lee Morse, Greg Rosenfeld, Richard Rubin, on behalf of Sheila Keen Warren, page 7.
Okay.
Good morning, Your Honor.
Good morning, Mr. Rosenfeld. Good morning, Mr. Scott.
Chief Scott, Chris Grimes, on behalf of the state of Florida.
Good morning, Mr. Grimes. Good morning, Mr. Lubin.
Good morning, Your Honor.
Glasses are fogging up there, Lubin. Your glasses are fogging up.
Yeah, I know. Top choice.
Okay, all right, okay. All right. So the first thing I'd like to talk about is the trial date that's currently affixed to this case. You filed a motion to continue.
Correct.
Okay. When will you be ready to try this case?
Judge, we are thinking end of March, beginning of April. As time then.
I got time then. How many weeks is it going to take to try this case?
2.
The March 21st trial week is a trial docket, 3 or 4 weeks then from then, so I can put you on for March 21st.
Your Honor, state may be heard.
Sure.
So I guess first, obviously the state objected to continuances, Your Honor.
Tell me why. Just tell me why. I mean, you think they should be ready by now? And
well, the cases in 2017 that I cited in my motion, there was 631 days before any deposition was set. I acknowledge some of the points that defense cited in the motion. We were in the grips of a COVID-19 pandemic, and there was slowdowns and things that had to happen. And while we certainly appreciate that, the state of Florida and the victims in this case are entitled to their day in court. And in the interim, during the pendency of this case, it is a cold case. Case from 1990. We've had some witnesses that have passed away. We have a motion on before Your Honor to perpetuate the testimony of another witness who is becoming firm. Every day that passes that goes by, the state is in the danger of losing another witness to the point where at some point we're not going to be able to proceed to trial because we'll have lost essential witnesses in the case that forbids us from actually presenting our case to the jury. And the defense has effectively objected to the perpetuation of testimony by agreeing to the perpetuation, but then only agreeing under the guise that, under the condition that their client is transported out of state for the perpetuation, which the state doesn't believe, that the case law permits. So the state is in a catch-22. We want to proceed to trial. The defense wants a continuance, and yet we're still not allowed to preserve crucial evidence that we're going to need to present our case to the jury. So given all those factors, the state is ready to proceed. We've made our objection. We'll be ready whenever the court wants us to, but we state wants to get this case to trial on.
All right. So, Ms. Morse, tell me about the reasons why you guys need more time.
Judge, I was not originally on the case when Ms. Keen Warren was arrested. However, throughout COVID and even before COVID, we have been taking a lot of depositions. And as Mr. Scott said, some of these witnesses are out of state. We have done so many depositions by Zoom. We've done everything we possibly could have. We are still getting witness lists. We received a witness list last week of a witness who was heavily involved and was questioned by police and state attorneys 30 years ago. I know that there are at least 2 other individuals that still need to be listed. We were unable to conduct an evidence view for more than a year. Even when we were able to go in for an evidence view, it's still limited to the number of people. And at that time, we came to the realization that some of the key pieces of evidence for the state were removed from evidence and sent to another lab in February of this year. To my knowledge, if the evidence is back, it's only recently been put back. We have not been able to bring our experts in for an evidence view for this reason. So our hands have been somewhat tied. So there are still some depositions to take. We do need to have our experts review the evidence. That's why we have not listed them yet. So we are proceeding as quickly as we possibly can.
Right. So, Mr. Scott, what's the deal with a late witness list now that the case has been so long? Why would there be witness lists still being filed?
I apologize. There was one additional witness that I noticed was not listed. He is a twin of another witness. The name of the witness was Don and Ron Carter. I assume that both Carter brothers had been listed. This is not a witness that was not known about by the defense. He's had multiple reports, given multiple statements. The information that he has has been well documented and turned over to defense. In my preps to get get my trial preparation ready to roll, I noticed that he had not formally been listed, although the defense well aware of this witness. So immediately I corrected that omission. The defense is right that I have continued to comply with my discovery obligation for criminal procedure and have updated them with notices of better addresses. If they requested a piece of evidence, I looked for the evidence and I promptly supplemented it. So yes, I have absolutely complied with my continuing discovery obligation. But that doesn't mean that I've been dilatory in any way. If any omissions have been noted, I've immediately jumped on them and got the materials.
All right. Part of my concern too, Mr. Scott, is I have not just this first-degree murder case, but many others that are set over the next few months. And so it's tough for me to block out 2 weeks. So just that's the difficulty I'm having too. That's why I figure that March date would be appropriate.
What would be just so that I understand, I have my trial calendar here at Your Honor, when would we actually be looking at trying the case, and could we get a date certain? Well,
that's the thing. If I can set it out that far, I can make all the reservations I need, and hopefully the other wild card is what's going on in our country, right? So right now things may be going backwards, and who knows what's going to be. I may not be able to field a 12-person jury in September. Right. So that's the other wild card. But right now I'm targeting that day, March 21st, to start the trial for the 2 weeks those 2 weeks. So.
Could I, and let me just ask, because we have a special set in Lee County that's supposed to start the end of February, could I indicate to the judge in Lee County that I'm supposed to be here before Your Honor on March, to represent that on March 21st?
Yes. Yes. Do we have no other commitments? Do we have any other conflicts on March 21st? Yeah.
If I needed assistance from Your Honor, maybe speak to Judge Porter.
Sure.
Lee County.
Yeah. Mm-hmm. Is he nice? Is he nice? I don't know. I don't want to talk to him now. How many jurors? At least 100 jurors?
100.
It may go into a third week.
Okay. Yeah. Okay. Well, I'm sure we'll be meeting before then. So let's go. Let's put it on the striker from September 8th. Put it on March 21st trial. And let me ask you, what else has been filed? I have a lot of stuff going on this morning, so you guys filed a bunch of other motions this morning.
So there's one other motion, the state's motion to perpetuate a witness's testimony, which we're in agreement with perpetuation, where we need your assistance. Is the rule indicates that if the defendant, Ms. Keen Warren, is in custody, that the sheriff must transport her there. I believe Mr. Scott's position, Ms. Bryan's position, is that she does not need to be transported. Our position is that pursuant to the rule and the confrontation clause, she does need to be transported.
You're talking about Regina Albaro?
Correct.
Where is she?
Well, no, we would need Ms. Keen Warren transported to her to perpetuate the testimony.
It couldn't be set up with some type of video monitoring at all?
Judge, we would disagree with that on a number of levels. One, I don't think it complies with the confrontation clause. Rule 3.190.
I need more time to deal with this, not today.
Okay.
I think it's a significant enough issue. I would deal with it on another day. And how long will it take to deal with this issue and also the scheduling order issue, which I'm fine. Can you guys agree on a scheduling order as far as taking all depositions in discovery?
I think the council will propose a number of dates. And we can submit that to Your Honor.
I prefer that. You guys work on that together, and if not, you can come see me and say, Judge, we haven't been able to agree upon this. And I'll just tweak the order or whatever, So hopefully you guys, as good lawyers, can reach an agreement upon the remaining, deadline on witness lists. There shouldn't be any more witness lists filed a month even before the trial date, right? Cutoff dates for witness lists, cutoff dates for taking a deposition. Everything should be ready. Cutoff dates for any other motions that need to be filed. Can you do that within the next, I felt like we had this discussion before. Did we not have this discussion? Maybe it's another case. 30 days from now. How about that? Can you do that within 30 days? Come up with a scheduling order?
Yes,
okay. And then, so scheduling order should be due by the end of August. Okay.
Yes, sir.
Judge, when would you like to hear the perpetuation?
You just get with my assistant, and we could probably do this sometime in the next 30 days too. I think it sounds like it should be more than a 15-minute hearing or so. We could probably do it on Zoom. I'd like to see you guys here. It's up to you guys. I don't think it needs to be, unless you need the defendant here for that. By the way, the defendant's not here. For some reason, she was supposed to be here. I don't know why she's not here. I hope you guys waive her presence for today. I never asked you that.
We'll wait for
Okay, all
precedent
right,
for
thank
today.
you. But even for something like that, do you need her to be there for, do you want her to be there for the motion to perpetuate testimony? Okay, and so I'm comfortable with doing that on Zoom. I know that I'll be here, you know, so.
Is there a way we can do that this week, Your Honor? If we have 15 minutes, just because.
How about this Friday? How about Friday? Okay, you guys going Friday morning, doing it Friday morning? We have a VOP Friday. We have a VOP Friday morning. What time does that start? We have a VOP starting at? How about 9:30 on Friday morning? All right.
Judge, we have one hearing in 4 hours, but it's going to be by Zoom.
Is that 10 o'clock better? Yes, 10 o'clock. 10 o'clock.
Thank you, Judge.
All right, 10 o'clock.
Thank you very much.
Thank you. Bye-bye, everybody. No.